A child custody order is always modifiable when there's a material change in circumstances for your child or children. Look, things change all the time, and the needs of a 2-year-old are not the same as the needs of a 17-year-old. And that means that the custody schedule that was in place when they were 2 probably isn't right when they're 17. And as children age, custody schedules often change with them. And that's a good thing. For a modification of child custody, there must be a material change in circumstances for the child, specifically for the child. It cannot be a change in circumstances for the parents. Let me tell you, a lot of parents get this really confused. They come to my office and they're like, oh, well, I've moved, I changed a job, I got remarried, I did all these other things. And if it's not a change for your child, it's not a material change in circumstances. Now, that doesn't mean a change for you couldn't also be a change for your child, but you gotta make sure that it actually is a change for your child. Why? Because courts want stability for children. So what kinds of things might be a difference? Maybe an increase in age, a significant increase in age. I'm not talking about they turned a year older. Maybe it's been 5 years and now a back and forth schedule doesn't work the same for a teenager who maybe needs longer stretches of time with each parent. Another thing is there might be a significant change in the health of a child or in the mental health of a child. Those can be really big changes that might mean the custody schedule needs to be changed. Maybe something about the current schedule is causing your child a lot of stress, or maybe the parents aren't agreeing on, for example, mental health treatment, and it is dramatically affecting the child. So anything that is a material change in circumstances can be used as a way to open the courthouse door for a court to reconsider what is in the best interest of the child or children today. If there has been a material change in circumstances, you can go back to court and file for a modification. And that might mean asking the court to change your child's primary residence. And there could be a variety of different reasons for that to happen. One case that I know about, the child was living primarily with one parent, and that parent's job got moved far away. But that child was in 11th grade, and they wanted to finish out their 11th grade and senior year with all their friends. They were in AP classes. They had their college application prep already in full swing, and they did not want to relocate. And that, in that particular case, was a good enough reason to change primary residence. Another reason why is if someone unsafe comes into the primary residence. Another case that I worked with, that parent started dating someone else, and that new person, unfortunately, was not a safe person to be around. That person was involved in a lot of unsavory things, and it made the child really, really uncomfortable. In fact, the child got into several really uncomfortable situations, told their other parent, and a modification happened, and it did change the child's primary residence. Now, courts in general try to keep things stable for the child, but when there is a change in circumstances, the court has to look at what's in the best interest of the child. Once that has been established, there is a material change, then the court redoes the best interest analysis. And the best interest analysis can shake out a number of different ways, including changing the primary residence of the child. Relocation cases are some of the hardest that we deal with. Relocation cases, for those of you who are unclear, is when one parent moves far enough away that the current custody and access schedule no longer makes sense or is viable. When somebody does move away, it has a big impact on the child, and it often means that the custody schedule has to be changed. And what does the court do? The court has to look at a bunch of different factors. If the person who has been, for example, the primary residential custodian is the one moving, the court may decide, hey, the stability of having the same primary residential parent makes the most sense, so we're going to send the child to move with that parent and rework the custody schedule. But the court can decide the opposite. I had a case where the child was in 11th grade, and even though she had been with the same primary custodian for, I believe, 7 or 8 years at that point, she didn't want to graduate high school somewhere else with people she didn't know. And the court did switch who was the primary residential custodian. And now the person who had been the primary parent, they were the ones who had access. And it was less than they would have liked, but that was the reality of their situation. So relocation absolutely has a big impact. But the one thing that I can tell you that courts are going to do is do their best to make sure that both parents are as involved in the child's life as possible. What should a father do if the current child custody arrangement is no longer in the child's best interests? Well, I'm going to start out by saying this: the same as a mother should do, because we are really lucky about where we live. Courts generally do a really good job around here, and I know that's not true everywhere, but courts around here do a really good job of seeing parents as parents, not as mom and dad. And if a child custody arrangement is no longer in your child's best interest, I don't care if you're mom or dad, you have to figure out a way to change it. And that might mean filing for a modification. But you also have to really look at what is not in their best interest and how big of a change are we talking here. Because once you open that courthouse door, once you say, hey, there has been a material change in circumstances that affect my child, in court, I want you to redo a best interest analysis and look at what's in the best interest of the child now, today, you're opening the door for the court to reconsider everything. And that can be good or bad for you, for your co-parent, and for your child. So think long and hard, talk to a divorce attorney, and make sure that you really understand what it is you're asking.